Next, we'll hear from Steve Brown, the Executive Director of the Rhode Island ACLU.
Thank you very much. I'm very happy to be here at this occasion. State legislative leaders have tried to assure us there's no need to pass legislation like this to protect women's rights because Roe versus Wade remains intact. But organizations like ours that have been fighting this issue in Rhode Island for 45 years now, and the women who are directly affected by restrictions on choice have to disagree with that analysis. I want to talk very briefly about the second part of the Reproductive Healthcare Act, which few people take a look at, and that section contains the detritus of the Rhode Island legislature's constant attacks on abortion rights over the decades. In 1973, immediately after the Roe versus Wade ruling, the General Assembly passed a law thumbing its nose at the court decision and declaring that life begins at conception. In the 1980s, the General Assembly passed a law forcing victims of domestic violence to notify their abusive spouses if they were going to get an abortion. In 2001, a federal court was forced to strike down a Rhode Island law that would have banned some abortions in the second trimester of pregnancy, even if the woman's health was at risk. The ACLU was able to get all those laws successfully struck down, and they're now unenforceable, but their continued presence in the general laws is a reminder of the fragility of reproductive choice in this state. While the attacks on abortion rights at the state level may have died down in recent years, as you've already heard, what is happening at the federal level is truly frightening. The current presidential administration has literally locked up young teenagers in their custody in order to try to prevent them from getting abortions, including in at least one instance that the ACLU handled a minor whose pregnancy was the result of rape. In the U.S. Senate last month, a majority voted in support of a 20-week abortion ban without any protection for women's health. And at the judicial level, the Supreme Court doesn't have to overturn Roe versus Wade directly in order to erode this very important constitutional right bit by bit. It is time to stop calling the threat to women's reproductive freedom hypothetical. It is not. It is real. Women deserve to be assured that their legal right to an abortion is safe in Rhode Island, and they have a right to be assured now, not when it's too late. The question isn't whether we should wait until Roe is overturned in order to do something about it. The question is, why hasn't this protection already been enacted? We are very hopeful that the legislature will pass this legislation this year. The time has come. And to paraphrase the House Majority Leader, it's time to put women at the table before the Supreme Court puts them on the menu. Thank you.